again with another video for small business owners or anyone that has a product or a service that they want to protect the value of the name or the image that is associated with their product or service. So trademarks can seem to be a very simple task. Basically filling out a form, submitting a picture of your trademark or your service mark actually being used, and submitting the application, paying the fee. That's it, right? I'm just like my clients. I like to DIY things. Part of it is just because I like to create things and make things, and part of it is because I want to use my money well. And so sometimes it may seem to me that it's better for me to do it myself, DIY, rather than pay someone else to do the service. However, there are definitely times where I outsource it, and I'm so glad that I outsource it because they do a much better job at that particular task than I either have the time to do or that they have already obtained the skill in doing. Trademark attorneys are no different. You have to think about it. What you see is just an online form that you are submitting is actually a form that was created by attorneys. And then that form is going to be reviewed by attorneys. And those attorneys are going to give you a response with knowledge that they gained in law school. So unless you have that specialized knowledge that usually comes through going to law school, sometimes even getting a Master of Laws, and then actually working in that field, you may be at a bit of a disadvantage in regards to your trademark application, which is going to cost you more money and more time in the end, as opposed to just going ahead and getting started with an attorney first. So an example would be between two different types of clients. Client A would come to me from the beginning and say, hey, can you complete this application for me? This is the mark, or this is the name that I want to get trademarked. I'll say, okay. And then I do, of course, do a conflict check. And then I do an analysis of their name and of any other marks that are associated with that business or with that service, right? And so what you may have thought was just, oh, I just want my name trademarked, or I just want this one image trademarked. There are a lot of other things associated with your business that you may want to trademark as well that you didn't think was that important. However, under the trained eye of an attorney, we're able to build a package that will protect your entire business from any other circumstances that may come up later on that you just didn't think about, because your original goal was just to protect what you see right now. It has value. Okay, and so that client can, obtain a flat fee because, the attorney, I'm starting from the beginning. And so I can anticipate everything because I'm, kind of in control of what is being submitted, right? So they can get a flat fee. And a lot of trademark attorneys will only require a flat fee to submit a trademark application. Now, let's take another client that has already started the application and they have received a non-final action or final action, and they need attorney help now because whatever they're doing is not working to get their trademark through. In those types of instances, a trademark attorney may not take you on a flat rate basis because it is more work. It is more time and it's more research to work with the trademark examining attorney or the person or the entity that is opposing your trademark application. It's a different skill set than starting the application from the beginning and not having any opposition because the attorney did the due diligence ahead of time. Now, does that happen in every instance where an attorney does their due diligence from the beginning and the application goes through? No, that's not always what happens. There are oppositions to attorney completed applications. However, the likelihood of you not being knowledgeable of that risk ahead of you actually submitting the application, I would say for me, is going to be low. because I'm gonna let you, because I started the application, I did the research to search for any conflicting marks ahead of time, and I've informed you as my client, hey, this is what we're up against. Do you still want to go forward with this? However, if you come forward with me after you've already started something and now I have to go and fix it, it's a little bit more expensive, because now I'm not just submitting an application, I'm actually attempting to fix a situation, right? So one day I was watching a show from the History Channel called, it was about like foods and where they started and how it's made. Anyway, so in this particular example, it was on candy. And so the individual that created the Babe Ruth bar originally wanted to call it the Baby Ruth bar. And so he went to Babe Ruth. Yeah, he wanted to call it the Babe Ruth bar. And so he went to Babe Ruth to get his permission to use his name, image, and likeness on the candy bar. Babe Ruth said, okay, that's fine. However, he gave him a price. The owner of the Baby Ruth candy bar determined that that was going to be too much money. So instead of getting the permission from Babe Ruth, he changed the name to Baby Ruth and trademarked Baby Ruth first. Now, Baby Ruth blows up. Everyone knows about Baby Ruth, right? Babe Ruth, later on, maybe like 3 or 4 years later, decided that he wanted to have his own candy bar and use his own name, image, and likeness to promote the bar. It was going to be called Babe's Home Run Candy Bar. And guess what? He was not able to use his own name in association with that candy bar because it was too close. It was the likelihood of confusion with the Baby Ruth bar that was already registered. And so even though it was his own name, he could not use that name in association with his own candy bar because it was already owned and already on the trademark register as for the Baby Ruth bar. And so you might be thinking, well, how did that happen? Like, how could someone else use someone else's name? Well, he stated that the owner of the Baby Ruth bar stated that the actual name for the candy bar did not come from Babe Ruth. It came from Grover Cleveland's daughter that passed away, whose name was Ruth. So, with that explanation and some great attorneys, the trademark application that Babe Ruth attempted to get filed with the United States Patent and Trademark Office, it wasn't called that then, that's what it's called now, was actually denied based on the likelihood of confusion standard. So that is one of the things that you have to take into consideration why attorneys are so important. Yes, you can do it yourself. Yes, you can, get your mark approved. However, when it comes to the totality of the circumstances surrounding intellectual property and how much money you can gain or how much money you can lose with your name, image, and likeness, you really and truthfully should go ahead on and invest in an attorney. Sometimes doing it yourself or DIY is fine. However, with something as important as your trademark or as your service mark, it's usually best to find an intellectual property attorney that is going to be able to assist you and counsel you to protect all of your intellectual property assets, as opposed to, doing nothing or waiting too late. So if you are thinking about filing a trademark application and you're thinking, well, I'll just do it myself, call my firm. Let's talk about it first, and then we can see how your investment may be better served with obtaining an attorney to complete the application for you. Okay? And so you can call my firm. The number to the firm is 866-823-9572. You can also email me at attorney@dominiqueyounglaw.com. You can also visit the firm's website at www.dominiqueyounglaw.com. See y'all next time.